Thanks, David. Our next speaker is Rockne Harmon. Rock is a forensic cold case consultant from Alameda, California. Rock.
Thank you, Joe. I'd like to thank the organizers as well. I was on the planning committee for the last one, and most of my work has been in DNA, so this was my first real exposure to trace. And I have to say, I was pretty impressed with the quality of the submissions, the kind of workshops. I think this program, especially that many of you don't have to pay for it, is really a quality production. It's much better than many of the DNA programs that are put on. So I'm going to start out on a little bit of a strange note. When I was a kid growing up in New York City, and I remember the first day I was going to walk to the School of the Blessed Sacrament on West 70th Street, and my mom took my hand and she said, "Rocky, when you walk down Columbus Avenue, be careful about who you make eye contact with." And I'm going to end on that note too, and I'll fill in a lot in between there. As a lawyer, I'm not going to tell you how to do things, but what I can tell you is how it interacts with the legal system. In this country, we have an adversary system, and it's based on legal precedent, which means that we're stuck with past experience influencing and dictating how our future scientific endeavors are absorbed into the process. So my first exposure was it's about 30 years ago with forensic serology. And for those of you who lived that long, I see one of them at least, can remember that what we could get at best was a failure to exclude. Not a lot unlike some of the trace evidence cases that you could imagine. So at the time, not surprisingly, there was an objection to that. It was too vague. ABO results were too vague. Oh, 40% of the population doesn't mean anything. And what you need to understand is, whatever you do, the person that doesn't like it, that it might work against their interest, is going to object to it. And that goes for the past, and that goes for the future. And so I'm remembering a trial I had in 1983 that's remarkably like a trace evidence question, but it was a serology question. It was a high-profile murder case, and the victim was found, and on her jacket was a mixture of semen and saliva, and we know she didn't produce semen, and we know the result was for more than one person. And lo and behold, when the suspect was arrested 5 days later wearing the same jacket he always wore, guess what he had? A mixture of semen and saliva that couldn't have come from him. And so it was the coexistence of those two comparable, not identical, but comparable stains in the context of all the rest of the evidence that was really compelling, overwhelming evidence when considered in the context of the rest of the case. Very much like trace evidence would be in any given case. I appreciate all the work you do, but you know the jury's not going to applaud when you leave the room because you've just provided some corroborative information upon which the rest of the case should be built or should depend. Many people use DNA as a model, and there's a reason they do that. Because none of the other forensic disciplines can attain that model. But don't be misled by the idea that DNA is a model. If you understood the complexity of some of the mixtures that are driven by newer technologies, the results that are being presented in criminal cases today or derived from those mixtures are virtually identical to trace evidence questions that you are seeing. It's a model that's used to hold you up to a model that you can't achieve. So let's think about what's happened with trace evidence historically in our legal precedent system. It was almost always admissible until the NAS report came out. And if you read especially the legal section of the NAS report, it was highly critical of the admissibility of all this other evidence. In other words, people who failed to achieve precluding evidence in court were criticizing the legal system then And that became one of the building blocks. We can't change the legal system, and we lose in the legal system, so let's try to change forensic science. Okay, that's all it was. Most of those law professors whose articles are cited in the legal section are non-scientist academics. And they disapproved of it. So what's happened since the NAS report to trace evidence? It's the same track history. The NAS report has had little or no impact on admissibility. And I say that because you shouldn't be deterred or dismayed by anything in there, because it is what it is, but it's not an impediment to admissibility. So if the things that you read, and I read a bunch of them on the plane yesterday, are not going to be presented in testimony in an admissibility hearing, because they're not really germane, then are we really going to see trials where these guys get to testify? Well, for those of you who followed the fingerprint litigation, do you realize that some of the primary critics were deemed not to be qualified as expert witnesses in it? In other words, they're qualified to write about it in a law journal, but they're not qualified as experts to testify about it. But being a former trial attorney, I would love to see that kind of testimony presented in trial, because then the focus is on all sorts of things like sequential unmasking and things like that, and not on whether or not you got the right answer. And juries can see through that anytime. That is not the level that this discussion is going to be had at. So what can I tell you? I can tell you what Joe said. Do what you think is best, not what somebody else tells you to do. If you saw the plenary session debate I had with Peter Neufeld, you are never going to please a criminal defense attorney. And if you look at the law journal articles that are written, you realize, much like research scientists, there's a publish or perish aspect to this. There will, as long as there's this disagreement or discussion, there will always be articles written about it. And I'd suggest if you're ever going to read one article by a person, look in their CV and read all of them. Gives you chills sometimes to read the titles of them. The adversary system, I was reading the New York Times online this morning. Here, the adversary system is always going to produce something for the loser to complain about. There's a story in the New York Times today, a child rape conviction. Her father was the rapist. They're challenging it because some of the victim advocates are bringing dogs to court to comfort the victims. And the whole idea is if the jurors saw the victim being nudged by the dog when the victim got distressed, this was a child victim, somehow the jury thinks the dog is encouraging the child to tell the truth. That's the basis for the appeal in those kind of cases. There's an underlying theme to all of this stuff, okay? And you can't help it. It's the elephant in the room. Much of this stuff is designed to undermine public confidence in the death penalty. That's never going to go away. And so to get back to the question of eye contact, do you really want to make eye contact with people who have this to say about you? It has always been striking to me the extent to which practitioners of forensic science in general and the traditional pattern matching disciplines in particular took for their patron and the instantiation of their self-image, their ideals, and their mission, not a flesh and blood human pioneer who had advanced the science of their enterprise in some empirically reliable way, but an imaginary person, Sherlock Holmes. I was unaware of that. I've never seen you wear Sherlock Holmes t-shirts at any of these parties we had, but that's from Mike, one of Mike's articles that he's written about forensic science. So, but I'll close. Do you really want to make eye contact with people who have that kind of disrespect for you? And I say, absolutely not. Thank you.